6 million. That's the number Congress subpoenaed. Pages, photographs, videos, everything connected to the Epstein files. 3 million. That's roughly what actually came back. The explanation given for the other half? Duplicates. Then a member of Congress pulls out a specific document, a 2019 prosecution memo, and says that one wasn't a duplicate of anything. It was public once, then it wasn't. Those are two different things, and I think the gap between them deserves a full, careful hour, because it's one of the more concrete, checkable disputes in this entire saga. 60 minutes today. Let's go through it properly. Fast version. Jamie Raskin, ranking member on House Judiciary, questions Attorney General Pam Bondi in a hearing focused specifically on DOJ compliance with the Epstein Files Transparency Act. This is a different kind of hearing than most of what we've covered with Patel. Less about personnel and more directly about paperwork, numbers, and a specific legal deadline. That actually makes it one of the more checkable threads in this whole series, because a lot of what's disputed here comes down to counting. The 6 million versus 3 million laid out precisely. Here's the actual claim, stated plainly. Raskin says Congress subpoenaed 6 million documents, photographs, and videos connected to the Epstein files. The DOJ released roughly 3 million. Bondi's stated explanation, the remainder is largely duplicative material. Raskin's specific pushback is where this becomes something more than just a number dispute. He points to actual victim statement memos he says are among the withheld material, and separately notes that the DOJ took down its own 2019 prosecution memo from public view. His argument, a document that was previously public and then wasn't, can't reasonably be called a duplicate of anything, because duplicates, by definition, are copies of something that still exists elsewhere. Removing something from view is a fundamentally different act than failing to release a second copy of it. Is duplicates actually a fair explanation for the gap? Let's actually test this claim honestly, because I think it deserves real scrutiny in both directions. Bondi's broader explanation involves genuine, real logistical constraints. She describes 435 member offices needing access, a limited number of computers actually available for review, and a hard legal deadline she didn't personally set. Reviewing 6 million pages at that speed, with those resource limits, producing some genuine duplication and some genuine gaps, is a completely realistic outcome, regardless of who's running the process. That part of the explanation holds up on its own terms. But the specific 2019 memo example doesn't fit cleanly into that explanation. If a document was previously public and is now not available, duplicate isn't actually the right word for what happened to it. It's either withheld or removed, and those are different legal categories with different implications under the Transparency Act's own disclosure requirements. So here's the honest split. The broader resource constraint explanation for the overall 3 million page gap is genuinely plausible. That specific document, if accurately described, needs its own separate explanation that duplicates doesn't actually cover. The victim statement memos, a different category entirely. Worth slowing down on this specific claim separately, because it's a different kind of document than the prosecution memo, and the distinction matters legally. A prosecution memo is a legal strategy document, the kind of thing agencies often have real, defensible reasons to withhold, even under broad disclosure laws, since it can reveal internal legal reasoning and strategy rather than underlying facts. Victim statement memos are a genuinely different category. Those go directly to the substance the Transparency Act was specifically written to expose. The law's own carve-outs generally call for redacting victim-related material to protect identity, not withholding the substance entirely. Those are two different legal treatments, protect through redaction versus withhold completely. And which one is actually happening with this specific batch isn't resolved anywhere in the hearing record available to us. That's a real, still open compliance question, not a settled one either direction.
The Maxwell transfer claim. Raised in the same hearing, Raskin also raises the Ghislaine-Maxwell situation directly in this hearing, noting the extensive multi-day interview she had with Deputy Attorney General Todd Blanche, and then a transfer shortly afterward to a facility Raskin describes as offering conditions atypical for someone with her specific conviction. We've covered a version of this before, but worth restating the structural point clearly here, since it comes up again in this specific hearing. The Bureau of Prisons is a distinct component within DOJ, separate from both the FBI and from Bondi's own direct office, specifically so that housing classification decisions for federal inmates don't rest with any single official's personal authority. That's the system functioning as designed, at least on paper. Whether the timing here, right after the interview, deserves more scrutiny from BOP specifically is a completely fair question. Whether anyone in the hearing directly establishes Bondi or Blanche personally directed the transfer, that connection isn't established in what's actually on the record. The timing is documented, the causal link isn't. The redaction pattern, both directions, checked carefully. A recurring theme across multiple Bondi hearings that shows up again here, victims' names appearing unredacted in some released material, despite the law specifically requiring their protection, while separately some members argue names of alleged associates got redacted, when the law's protection was meant for victims specifically, not third parties. Bondi confirms directly on the record that redaction errors involving victim identities occurred and states her office corrected them once identified. That's a confirmed fact, not in dispute. What's still genuinely contested, whether the broader pattern reflects honest, rushed process under real deadline pressure, or something closer to an intentional asymmetry in whose information gets protected. The transcript settles the first part cleanly. It does not settle the second part either way. Why redaction errors at this scale aren't automatically suspicious? Worth being genuinely fair here, because I think this deserves real weight. Reviewing millions of pages under a hard legal deadline with real resource constraints is going to produce errors in both directions almost no matter who's running the process. That's not a defense invented for this specific situation. It's just a realistic description of what large-scale document review under time pressure actually looks like across government agencies generally. The fact that Bondi confirms the errors rather than denying them and describes an active correction process is actually the more accountable of the two possible responses available to her, and that's worth crediting directly rather than only focusing on the fact that errors happened at all. The compliance standard itself, the actual legal hinge. Here's the piece I think ties this entire hearing together, and it's worth stating plainly because it's the actual legal question underneath every specific dispute we've covered today. The Transparency Act requires release of legally permissible material with explicit carve-outs for victim protection and active prosecution. Every single dispute in this hearing, the page count cap, the redaction pattern, the withheld prosecution memo, is, at bottom, a disagreement about how broadly or narrowly those specific carve-outs are being applied. That's not a minor technical detail. It's the actual legal hinge the whole document release controversy turns on. Bondi's position is that DOJ met its obligation to the fullest extent the law allows under real time constraints. Raskin's position is that specific examples, like the 2019 memo, show the carve-outs being applied more broadly than the law intended. Both positions are coherent legal readings of the same statute. The hearing itself doesn't resolve which reading is correct. Okay, full fairness pass. Everything today. All real pushback across all of it. On the 6 million versus 3 million gap. Genuine resource constraints under a legally imposed deadline are completely realistic, non-suspicious explanation for a significant portion of that gap, regardless of who's running the review process. On the 2019 memo specifically,
It's possible the memo's removal from public view reflects a legitimate legal basis we simply don't have full visibility into from a single hearing exchange, rather than an improper withholding. Without seeing the DOJ's own internal justification for that specific decision, treating its removal as automatically improper would be an overreach in the other direction. On the Maxwell transfer, BOP's structural independence from both the FBI and the Attorney General's direct office is a real safeguard specifically designed to prevent any single official's involvement in exactly this kind of decision, which supports treating "that wasn't our call" as a plausible, accurate answer. On the redaction pattern, confirming and correcting errors rather than denying them is the more accountable response available, and it deserves to be credited as such, rather than overshadowed entirely by the fact that errors happened. What people who actually handle document production professionally say: document review specialists who work in large-scale litigation discovery note that reviewing millions of pages under a hard deadline reliably produces both duplications and gaps, almost regardless of process quality, which supports treating the broad duplicates explanation as plausible for the bulk of the gap, while still leaving room for specific documents to need their own separate explanation. Federal disclosure law attorneys discussing statutes with multiple explicit carve-outs like this one note that redaction and withholding patterns that look uneven from the outside don't necessarily reflect bad faith. Distinguishing genuine misapplication of a carve-out from its legitimate use typically requires reviewing the specific unredacted material directly, which outside observers generally can't do without a court-ordered review. Federal prison policy specialists on the Maxwell transfer question specifically reiterate that housing classification decisions are structurally separated from both FBI and DOJ leadership for a specific long-standing institutional reason, supporting real caution before assuming any connection between the interview and the transfer beyond simple timing. Real talk: why this actually matters beyond one hearing. The page count and redaction threads matter because they are a direct test of how much any government agency should have to show its work when handling records that touch real people's privacy, a question that applies anytime you or anyone else files a records request about anything from any agency. The Maxwell transfer thread matters because understanding how federal institutions deliberately divide authority, specifically to prevent any single official from controlling sensitive decisions alone, helps you evaluate any claim about institutional overreach you'll encounter in any context. That's the hearing, worked through as carefully and fairly as I can manage. A real documented gap in the numbers, a specific document that deserves its own explanation, and a redaction dispute that's honestly still open in both directions. Subscribe if you want the next update the moment any of this gets clarified further. Drop below. Do you think the duplicates explanation holds up for the bulk of the gap, or does the 2019 memo example undercut it? Talk soon.